All right, welcome back. So, yes, that's what we'll focus on this morning, the Ibom Northwest Senatorial Tussle. We've got Mr. Ofyong here with us. He is a senior advocate of Nigeria. Good morning, and thank you for coming on today.
Thank you for having me, Chamberlain. Yeah.
Well, lots of people still trying to digest that, what transpired, as it were. But you heard Mr. Okoye there, and you've also have read the reports about that particular decision of court. There are several things. First of all, what is your impression of how this court case has been handed down?
Well, let me start by also acknowledging that I have not seen the full text of the judgment, just like my friend and learned friend, Mr. Festus Okoye, stated. Now, it is always difficult for anyone who was not a party to the case, who was not counsel in the case, who has not read the judgment, to give an informed opinion of why judgment went the way it did. But having said that, what I can say about the case is that it's one of those cases which the Constitution defines as a pre-election case. Pre-election are defined in three senses. One, where an aspirant to a political office under the Constitution is complaining about the manner in which the political party to which he belongs has conducted the primaries, either in breach of the Electoral Act, their own guidelines, or the Constitution. And then, of course, that is a pre-election matter. The other aspect of it, and I think that is the pertinent one in regard to the conversation we're having this morning, is where an aspirant complains about the conduct of INEC in connection with the decision which they have made touching on his capacity to contest the election. Of course, the third category is where the political party complains about the conduct of INEC. So the particular action can be posited within the second ambit, which is an aspirant here, which is the distinguished former senator for the Akwa Ibom Northwest, is complaining about the conduct of INEC. So that gives him the status, or what we call the locus standi, to make the complaints which he's making. The other point which the public may be interested in knowing about is that when it comes to the Electoral Act 2022 has actually radically reshaped the space or the primary environment of political parties. In the earlier version, which has been amended, what the law required was that the political party should submit a list of candidates and then specifically enjoined that INEC cannot reject the list, any candidate submitted by the political party.
But there are condition precedents.
Yeah, but it actually said it wasn't the business of INEC to reject them. That was the 2010-2011 Electoral Act as amended. But in the 2022 Electoral Act, particularly Section 29, it says that the political parties should submit a list of candidates for the election who should have emerged from a valid primary conducted by the political parties.
Valid primary?
Yes.
So what if they submit a name that is not a valid primary?
Exactly, that's the point, okay? So, and then it deleted the provision in the earlier version of the Act, that's the 2010 and 2011 version of the Act, or if you like, up to 2015 amendment of the Electoral Act, which prohibited INEC from rejecting the names of any candidate. So, in my view, INEC would be within the powers to say, look, you have not submitted to us a name of a candidate who who emerge from a valid primary. Matters are not helped by the fact that Section 84 of the Act requires that INEC must monitor. In fact, it uses the word shall. And in legal lexicon, when the law uses the word shall, that's compulsive, that's mandatory.
In other words,
it says,
if INEC does not monitor the primary, it validates.
It says that if INEC does not, INEC must monitor. It says shall be monitored. Political parties shall produce candidates who hold primaries, which shall be monitored by INEC. Now, so it is true though that sometimes the court look at the word shall and interpret it as may, discretionary. But in my view, that section would not be one of those sections. And the reason is that when you look at the whole context of that section, it actually then goes on to emphasize that any political party which has not complied with that provision of that section, Section 84, or the Electoral Act generally, but will not produce, will have his candidate, will not participate in the election.
In other words, you're saying there are contexts where you can interpret shall as may, and does that mean you can also interpret may as shall?
Oh, of course. There are contexts in which you can interpret may or as shall. Again, so unless I've seen what was argument, my view as at now is that the context of Section 84, the shall, in the context of Section 84, subsection 1, is mandatory, that it will not yield itself to being interpreted as may, because the consequences prescribed for failure to comply with that section.
Okay, we'll explore that a little further, but some of the circumstances surrounding this particular case, there are those who are asking questions. For instance, the camp of Deji Kudom, who was on the seat, says that, wait a minute, we're not even joined in this case. There are parties to this particular case. Okay. So how is it that the judge or judgment can come through when parties in the case were not even joined in the matter? They were not aware of this matter.
Okay, all right. So there are two things to be said there. Number one is this, that the law as it stands is that if you are going to take up a suit, you must join the necessary parties. Now, it is the plaintiff who nominates who the necessary parties are in his case, because it is a complaint that determines who the necessary parties are to his case. So unless I see what the complaints of the plaintiff was in the, either the rejecting summons, or some people are using, taking out these proceedings by way of writ of summons and statement of claim. So whatever it is, the means by which they initiated this process, I would need to see the reliefs they sought, the claims they made. That will determine whether or not the party, Ekudum, was a necessary party. But there's something interesting I read. Like I said, I've not read the full text of the judgment, but in the course of reading newspaper reports of that judgment, one of the things that emerged was that the trial court, the Federal High Court, His Lordship Justice Mwite, seems to have taken the view that the Ekudum primaries was a primary not conducted by the authorized by the National Working Committee of the All Progressives Congress. Now, again, the law is very settled on this, that the primaries conducted, the only valid primaries which the law recognizes is one which is conducted on the authority of the National Working Committee.
And in that, so now, if in this case, because they argue that since we were not parties to it, and if we understand the argument properly, they say, well, he just joined INEC in this case. So
I was actually going to add a second thing, which was this, that first I've made the point that it's the plaintiff who nominates who the parties are, because he's the one initiating the process. And whether the necessary parties or not will be determined by the claims before the court. The court actually also has a discretion when the matter is brought before it to join parties who he considers are necessary but were not joined
in the matter.
So that's one part of that's the second part of it. The third part of it is this: Ekudum himself when he heard of the pendency of the case,
should have applied
to be joined
in the matter.
So if you stand by and allow litigation to go on, which your interest is affected, and you've not joined, then of course you have yourself to blame. As a matter of fact, the Supreme Court has just given a decision very recently. The case of the Ebonyi State case, Odi and the other senator.
Senator Ogba.
Ogba, that's right, yes. Again, that was a very interesting case. It was a case where Oba was not joined. Odi went to court. He sued PDP. He sued INEC. He did not join Ogba. Now, the lower court, that's the Court of First, the Federal High Court, came to the conclusion that Oba had not been joined, and that Oba had not made even the application to be joined, and went on to determine the case on the basis of the claims made by...
But there was some confusion there, because they said, look, how is it that the court said, well, they upheld the appeal, and in the same breath, ordered the retrial? So they thought...
No. That's a different case. That's a different case. The what case I'm talking about, at least, I have been privileged to read the judgment up to the judgment of the Court of Appeal. Okay? And so the narration in the judgment of the Court of Appeal was to the fact that on the day, I think it was 7th of June, when the case came up, Senator Oba, did not have an application before the court for joinder, and then proceeded to give judgment in the contest between only Odi and INEC and PDP.
Again, the discretionary matter was not...
No, the issue of discretion did not come up, that's all. Then Oba appealed to the Court of Appeal. And at the Court of Appeal, and here's why I say it's interesting. At the Court of Appeal, the issue was raised that Oba, you were not a party to the case.
So how do you appeal?
In the Federal High Court. And therefore, if you want to come here, you should obtain leave,
of course,
to be joined as a party, as an interested party. The Court of Appeal took the position that, look, these are a free election matter, and leave is no requirement for anyone to appeal.
But the Supreme Court didn't agree.
The Supreme Court did not agree. So the position, therefore, the final position is the matter has now been determined as between Odi and the INEC and PDP, without Oba having an opportunity to have any say. So again, that speaks to the fact that if Ekpudum still thinks that he's been shortchanged in the judgment which has been given, he should get to his legal advisors very quickly so that they can do the needful. But otherwise, he may remain shut out forever.
But they also argue that there's a case in court that is going to be determined, I think they're saying 6 days or thereabout.
Yes.
Where all the parties are joined in the matter on this same case.
Very good.
So if and when the judgment comes through,
yes,
does it invalidate this particular one?
No, it's not going to invalidate this particular one. It's not going to invalidate this
particular one. Even though it's the same subject matter?
Yes, it's not going to invalidate, because the courts are courts of coordinate jurisdiction. So one judgment of a coordinate jurisdiction cannot invalidate the judgment of another coordinate jurisdiction. But
we've heard INEC say, look, when they give two judgments like that, they ask, well, which one came what? Is it first or recent?
No, that does not. The issues of abuse of court process cannot arise in this case, because Mepudum was not a party to that one. Now, and here is the point which I make. The practitioners who appeared in that case, they know probably what they were doing, but if I could have suggested anything to them, it would have been, if you are aware that there's a case pending before the Federal High Court, and happily it's only the Federal High Court, and the Federal High Court jurisdiction runs throughout the country, the appropriate thing to have done would have been to apply to consolidate, to the court to consolidate the two cases and hear them together, rather than allow the situation of this one proceeding to judgment, a different judgment, and the other one proceeding to a different judgment. The ultimate result is going to be this, that you have to appeal the two cases. And it's only the Court of Appeal that would then be able to intervene and decide, okay, this particular one is the one which is upheld. This other one is the one which is not upheld. But until the Court of Appeal does that, the two judgments remain existing and valid.
Wow.
The problem, of course, would be that if the other judgment contradicts the current judgment, if the anticipated judgment now contradicts the current judgment, it's going to put INEC in a difficult position. And therefore, it will become necessary for INEC to choose which of the cases it would appeal.
Which is what is likely going to happen, because they argue, the one that will be delivered in 6 or 7 days' time, that the judgment was based on false documents that they presented the court. That's why they didn't join them. But those are just what is. Well, the court will decide. So when they decide,
yes, that's I was not going to say the same thing. That when a matter is before the court, it's up to this. I can't.
Yeah, so we'll wait until that happens. So let's get to Lagos. My colleagues have got some questions for you. Go ahead, guys.
Right. Thank you, Chamberlain. Senior advocate. So weighing both cases, Justice Nwite's judgment, and I believe the one to be decided by Justice Okorowo, if I'm correct. So Justice Nwite's case had, INEC and Senator Akpabio as the plaintiffs, and the other one had some more representation, including the other aspirant or candidate, as the case may be. In terms of fair hearing, because for the Justice Nwite's case, it was essentially Senator Akpabio petitioning against INEC, as it were, for not publishing his name. But the other party's case was not presented there. Would you say, or do you think that, strong points will have been made, perhaps by the INEC's lawyer or the INEC's counsel, such that it maybe at least represents the other party in this case? Because the argument for a lot of people is that maybe INEC's counsel did not present the other sides of the case. For example, the fact that Senator Akpabio was already in the running for the presidential ticket of the APC as well, and perhaps a conflict, participating in two primaries, even though he withdrew eventually. So in terms of that, would you say that Justice Nwite's, at least the case before Justice Nwite that was decided, was fair enough in terms of representation?
I've previously said, unless you see the claims made in the Justice Nwite judgment, it's difficult to say who else should have been a party to that case. But one thing I'm clear about is this, that if you have two cases, both seeking to determine similar questions, or questions which are going to have impact on the other, prudence would suggest that to avoid a state of conflicting judgment, that you apply to have the two cases consolidated and heard together. Why that wasn't done, I wouldn't know. Since I'm not the counsel in the case, I wouldn't know what the counsel know, which made them not take that option. But looking from the outside into the case, that's what I would have thought should have been done. And and when you speak about the fairness of the hearing before Justice Nwite, it all depends on whether or not the question of Akpabio, Senator Akpabio, contesting in the presidential primary was brought up in that case. Again, is the parties who nominate what issues they are agitating for before the court. It is not for the courts to jump into the arena and pick up matters which the parties have not raised. And if what was alleged against INEC did not concern the presidential election, it is doubtful whether INEC would have raised that. And in any event, I think that is an absolute speculation for anyone to say what INEC raised or INEC did not raise, what argument INEC preferred or did not prefer, because no one has, at least I have not seen INEC's response. Right. I've not seen INEC's written address on the subject, so I can't speak to any lack of agitation of the correct issues before that judgment.
But I'd like you to speak to the point you made.
You can't...
pardon me, you can land on that point quickly.
Okay. You can't anticipate what you say the other judgment coming up before Justice Okoro. You can't anticipate what he would decide. I can't even speculate on what the issues before that court are.
Okay.
So I can only speak generally.
Okay, two issues
what I
quickly.
know to be the state of the law.
But pardon me, two issues quickly. So first is, whose call should it be then to sort of harmonize those cases? Because, I mean, we've had that issue before. I recall in the case of Rivers, people getting ex parte orders here and there, and people wondering, did you know that this case was ready before another court? I mean, people go into different states just to get those orders and all of that. So whose call should it have been to sort of harmonize and ensure that, I mean, no one knows how the coming case will go, but I mean, what if they conflict? That could have been avoided. So whose call? Is it the judge? Is it the councils? Or who? Who should have made that call, perhaps?
Well, the first, okay, let me start from the beginning, from the end, and then I can get back to the initial initiating process. Now that this has happened, one judgment has been given already, and another judgment is likely coming up. It will be left for the Court of Appeal to harmonize whatever the judgments are. If it turns out that the judgment in Mwite is the same as the tenor of the judgment in Mwite is the same as the tenor of the judgment in the other anticipated case, then, of course, what will happen is that both whoever is aggrieved will go up to the Court of Appeal. But even if they're divergent, what will still happen is that the reconciliation would take place in the Court of Appeal. So the harmonization, as you call it, will take place in the Court of Appeal. But I do need to also mention something else. The National Judicial Council had taken a policy position that in respect of these political cases, the heads of court should issue practice directions which ensure that these cases are filed within the judicial division where the events occurred. So, for instance, if you are talking about the Mwite judgment, Justice Mwite's judgment, that case, by the practice direction of the Federal High Court, which is actually in conformity with the policy direction issued by the National Judicial Council, ought to have been filed in Akwa Ibom. So also the other anticipated judgment, because they all raise the question of the primary election for Akwa Ibom Northwest Senatorial District. However, what has happened is that because the Federal High Court went on vacation, many of these cases are being heard as by the judges who are in those divisions, the vacation judges. And sometimes, because the chief judge of the Federal High Court also has the authority, notwithstanding the provision of that rule, of the practice, the pre-election practice direction 2022, to assign the case to judges outside of that state. So the conclusion I want to draw is, if a case is filed in the registry of the court, it should actually be brought to the attention of the chief judge, wherever it is, with these pre-election cases, so that it can then direct that the cases should be heard in one place. Ultimately, it is the chief judge who directs cases to be heard by any of the judges. So I think that that kind of harmonization should take place. And I can also add that something very useful, the president of the Court of Appeal has taken a very useful step in passing what has come to be known as the pre-election appeal, political cases, political leadership practice direction. And the tenor of it is that wherever an appeal is filed touching on either a pre-election matter or a political leadership matter, it must be brought to the attention of the President of the Court of Appeal, who will then make special arrangements on how those cases will be heard. And the purpose of that rule is, as stated in the rule itself, to avoid a situation of conflicting decisions. I think that's something which the heads of courts, particularly the head of the Federal High Court, could very usefully borrow from by ensuring that whenever any of these cases are filed, particularly touching on a particular state, multiple cases filed, if it could ensure that they are brought together and assigned to the same judge, it would avoid the scenery which we are discussing here. That would be my suggestion.
Well, Senior Advocate, I'm interested in the outcome of this judgment, perhaps especially as it has to do with the spirit of the law. I noted that you said earlier that Justice Nwite seems to have taken the view that the primary conducted by the APC in the state was not monitored, was not duly approved by the National Working Committee of the All Progressives Congress in Akwa Ibom State. Now, could the judge have also noted that there were factions of the political party in that state and as a result ruled differently, or perhaps ordered a retrial of some sorts of the primaries?
No, I think the answer to that is very straightforward. The courts, in terms of primaries, the authority to conduct primaries, it does not belong to the state executive of the party. So whatever the faction is in the state, they do not have the authority to conduct primaries. The law is well settled that it is only the National Working Committee of the party or the National Executive of the party which can conduct party primaries. So without any regard to factions or whatever existed there, once the state executive cannot conduct primary, it doesn't matter which faction conducted it, it would not be recognized. It's only the primaries conducted on the authority of the National Working Committee that received the recognition of the law.
But then INEC, in its earlier reaction to Senator Akpabio's claim to the ticket, had said that it did not monitor the primary that produced Senator Akpabio. Hence, it would not recognize Senator Akpabio as the candidate for Akwa Ibom Northwest Senatorial District. Why didn't the court also take this into cognizance, knowing full well that any candidate that will be produced at the primary level must have INEC officials monitoring that primary?
Okay, very good. And that's a very, very good question. Now, the existing regime for monitoring primaries is this, that the national headquarters of the political parties actually are the ones who write to INEC. INEC entertains communication from the national headquarters of the party. So, for instance, if a date for the primary is fixed, the first thing is that the courts take the view that this is a primary of the party. It is the business of the party to conduct the primary. So they fix that date. But once you fix that date, you have to mandatorily inform INEC 21 days before the date of that primary. So, and INEC would entertain communication from the national headquarters. Secondly, the national headquarters is also the organ, the National Working Committee, that appoints members of the State Congress Committee, the State Primary Election Committee. So, invariably, INEC also is informed through the same national headquarters of those who have been so appointed. And so it is those people who will now go to the states. And as my friend Festus Okoye has been very insistent and very stringent in emphasizing, the national headquarters of INEC have their election monitoring team. So they invariably send the election monitoring teams to the states. And when they get to the state, they liaise with the INEC in the state to monitor the elections. Now, so I expect, and that's where the INEC monitors know better than any one of us. The INEC, so the election they monitored, who were the people the APC informed them were the state Congress or the state primary election committee member to conduct that election. Those were the people who were to get in touch with INEC and tell INEC, here is the venue of our election. In fact, alongside with the letter informing INEC of the date of the election, which must be 21 days to the date of it, they must also have informed INEC of the location, the venue where the election was going to be held. And it is on that basis that the INEC monitoring team coming into the state goes to do the monitoring of the election. And it's the INEC monitoring report becomes very significant in that context.
And it's usually headed, INEC's team is usually headed by the Resident Electoral Commissioner in that state.
Not necessarily. The Resident Electoral Commission in that state, well, let me not speak about the internal matters of INEC because I'm not sure. This is not what is written into the law. Okay. What I do know from what our friend Festus Okoya said many times is that they rely on the INEC monitoring team. The state, the Resident Electoral Commission, is the head of INEC and the representative of INEC in the state. So the usual problem is that becomes an internal problem. If INEC is sending officers from the headquarters and those officers are junior in rank to the Resident Electoral Commission, of course, is that team. If he chooses to go with them, he would be the head.
Well, we've been told several times that INEC's team is usually headed by the REC in the States.
Oh, great.
So that's what they say, because
fine.
They can't be working across purposes.
Fine. So if that's the case, I can't speak to them because it's not written into the law or the guideline, but I've heard the same thing being said.
Yeah. Well, clearly there are some issues there. The one for the courts wherein they need to ensure that there isn't that loophole where they are aware of similar cases going on so they don't give conflicting judgment. That has come up several times, and we're hoping that that can at least be addressed so that you don't have judges saying, well, I didn't know about this, then I give this order, and so it gives a lot more headache to the public, as a matter of fact. And if I could just end with reading this section 8413 of the 2022 Electoral Act, where it says, quote, where a political party fails to comply with the provisions of this act in the conduct of its primaries, its candidate for election shall not be included in the election for the particular position in issue. So who knows what to expect.
And that's why I'm also surprised at the judgment of Mwite, the one which is being spoken about now. And the reason is this. If INEC did not monitor that election, that is clearly a non-compliance with the conduct of primaries, because Section 84, subsection 1, mandatorily requires INEC to monitor that any primary from where a candidate of a political party is to emerge. So I have a problem there. We'll wait and see what the Superior Court say about it.
All right, we'll wait and hope to see what happens. Well, we have to thank you very much indeed for coming on this morning. Mr. Ofiong is a senior advocate of Nigeria. We will be back in just a moment. Stay with us.